I'm especially privileged to welcome Bill Tambussi, whom I've known since he was a child, more or less. He is a partner in the outstanding law firm of Brown and Connery in New Jersey. He concentrates in labor and employment litigation as well as government affairs and complex litigation. Bill has been certified as a civil trial attorney by the New Jersey Supreme Court since 1991. He represents both public and private sector clients, including the County of Gloucester, Lockheed Martin, as well as serving as the Special Labor and Employment Counsel to the Camden County Health Services Center, in addition to many other positions he holds. Mr. Tambussi earned his graduate degree from Dickinson College and a law degree from the New England School of Law. And I would also mention he's here today in his capacity as General Counsel for the Cooper Hospital University Medical Center, a name that's probably now known across our country. I think most people know that our governor of New Jersey, Governor Corzine, was involved in a near-fatal car accident just a few weeks ago. And, Bill, I hope that you would convey to the men and women at Cooper Hospital the great respect we have for the great work they did in healing our governor and bringing him back to work. I hope you'd pass that along to the people at Cooper. Thank you very much.
Thank you, Chairman Andrews and members of the committee. Thank you for allowing me to appear and testify on behalf of the RESPECT Act. Chairman, I'd like to thank you for the kind words of introduction. We have known each other for such a long time. I will focus my remarks today on the implications of the bill for labor management decisions in the acute care hospital setting, and specifically in terms of the trilogy of the recent cases or decisions of the NLRB. I will also use Cooper University Hospital as an example with which I have a great deal of familiarity, having been the hospital's legal counsel during labor negotiations with its unionized nurses, who are represented by the Health Professionals and Allied Employees Union. In the Cooper model, what distinguishes the supervisory role, particularly of those employees involved in nursing care, are three essential attributes. The individual is involved in setting compensation. The individual is involved in decisions regarding hiring and termination and also discipline. And the individual is involved in scheduling decisions regarding assignment of staff on a weekly and monthly basis as opposed to simply a shift basis. These criteria clarify the boundary between those employees of the professional nursing staff that are part of the bargaining unit and those employees who are genuinely supervisory employees and act in a managerial capacity. At Cooper University Hospital, charge nurses do not fit that practical criteria and are not considered supervisors or management employees. Rather, charge nurses are part of the existing registered nurses professional bargaining unit and recognized as such by Cooper University Hospital. That said, charge nurses at Cooper Hospital do use independent judgment to assign and responsibly direct other nurses and technicians and licensed practical nurses with respect to patient care. That is, they have the kind of authority that the board has found to be supervisory. These charge nurses must exercise these duties to provide effective patient care. It is a function of their professional licensure. In addition, the charge nurses at Cooper are responsible for staff assignments within the narrow confines of a given shift, not longer-term assignments between shifts and units. It is important to point out that all Cooper nurses, not just charge nurses, use their independent judgment in the course of their professional practice as nurses. For example, all nurses, to some degree, assign and responsibly direct other employees, such as technicians and licensed practical nurses and other hospital employees. Nevertheless, the performance of these duties by charge nurses does not, in the Cooper model, make charge nurses supervisors. This system works because Cooper values having a collective bargaining relationship with these professional workers as part of a single bargaining unit. Moreover, in this model, Cooper retains management prerogatives and authorities in the workplace and exercises such prerogatives and authority through its designated supervisors. If the RESPECT Act is enacted, It will not change or affect the Cooper model because Cooper does not consider or define charge nurses who assign and responsibly direct other nurses, technicians, licensed practical nurses, and other staff personnel with respect to patient care as supervisors. Further, the RESPECT Act would not interfere with managerial prerogatives exercised through designated supervisors. From my own vantage point, in terms of having practiced labor law in bargaining table negotiations and in courtroom litigation, I believe that the RESPECT Act provides clarity to the current situation in light of the recent conflicting decisions by the NLRB. The Act eliminates the highly ambiguous terms assign and responsibly to direct from the definition of supervisor, terms open to confusion and misinterpretation and inconsistent application. The clarity achieved by the RESPECT Act reflects both the original intent of the NLRA's framers and everyone's common sense and practical notions of who is a supervisor in the workplace. So long as these employees are not engaging in or have the authority to engage in other supervisory duties as defined by Section 211 more than 50% of the time, if all they are doing is assigning or responsibly directing, that is not reason enough to treat them as supervisors. An employer like Cooper University Hospital recognized this and is able to maintain effective labor relationships in that framework. To sum up, the decision of the board in Oakwood Healthcare and a comprehensive dissent to that decision does little to resolve the issue from a practical standpoint for those of us in the field, at the bargaining table, or at counsel table. The board's observation that debating linguistic niceties does little to realistically assist in formulating working definitions that fit both the language of Section 211 and the overall intent of that provision has become a self-fulfilling prophecy, begetting yet more debate of linguistic niceties. Accordingly, it is in everyone's best interest to temper the debate and focus on the practicalities of what can work in the workplace, as Cooper University Hospital has done. Thank you, Mr. Chairman.